Good morning to everyone at today's public hearing of the Vetting Commission established under Law 65, the year 2023, on the external evaluation of judges and candidates for the position of judge on the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. The hearing is being conducted under the Commission's rules of organization and functioning as part of the evaluation process. The subject of today's hearing is Dumitru Mardari, candidate for the position of judge on the Supreme Court of Justice. Mr. Mardari is currently an attorney at law. From February 2014 through the 20th of March 2023, he served as a judge on the Supreme Court of Justice. Prior to that, for nearly 20 years, he had been a judge on the Chisinau District Court, including serving for approximately 8 years as the president of that court. Judge Mardari, welcome. I'm joined by 5 other commission members. To my left is Vice Chair Andre Bevel and commission members Lavle Perling and Yuri Gatskin. To my right are commission members Lillian Ansu and William Brower. The commission is also assisted by members of its secretariat, and you may notice in the room some members of the public or the media. A photographer is also present who will take pictures just briefly at the start of the hearing. The hearing is being conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask that everyone speak slowly and clearly. Only one person should speak at a time. The proceedings are being recorded. The recordings of the Commission's public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days of the hearing. During the hearing, one or more members of the Commission may ask you questions. I ask you to answer them truthfully and completely. Your answers are important to the Commission in verifying your financial and ethical integrity. At the end of the hearing, you will be given an opportunity to make a brief closing statement. In posing questions, we will consider your privacy and, where appropriate, the privacy of your family members and close persons. Accordingly, we will not refer specifically to things like ID numbers, residence addresses, bank account numbers. We ask you to do the same in order to protect privacy. I will start by briefly reviewing the evaluation process for Judge Mardari. The Commission initiated its evaluation on the 14th of February 2024 by sending him an email and asking him to complete and return an ethics questionnaire and the financial declarations required by Law Number 65. He returned the completed declarations and questionnaire on the 19th of February 2024. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. On the 22nd of April 2024, the Commission asked Judge Mardari to provide additional information to clarify certain matters. He responded on the 30th of April with additional answers and documents. On the 8th of May, the Commission asked Judge Mardari to provide additional information to clarify certain matters. He responded on the same day, providing the requested answers and documents. On the 12th of June, the Commission asked Judge Mardari to provide additional information by June 19th. He did so. On July 4th, 2024, Judge Mardari also submitted additional documents. On the 26th of July, the Commission asked Judge Mardari to provide additional information by August 2nd. He provided his answers and presented the requested documents. On the 6th of September, 2024, we notified Judge Mardari that the Commission, in its investigation, had identified some areas of doubt about his compliance with the ethical criteria, and we invited him to attend today's hearing. Judge, at the outset, let me ask, do you wish to make any corrections or additions to the answers that you've provided to this point to the Commission's request for information? Excuse me. Merci.
Bună ziua, domnul președinte. Good afternoon, Mr. President. I would like to greet the members of the Commission also. I don't have additional information. I try to make sure that I answer all the answers within the deadline, and I'll try to offer answers to the doubts of the Commission. I do not have any other information.
Thank you. And are the answers to the ethics questionnaire that you returned on the 19th of February 2024, are they still accurate as of today?
Yes, they are still valid. Nothing has changed.
Okay. Well, Commission members may now ask some additional questions. We will try to keep our questions short and to the point. We ask that you try to answer similarly. Commission member Andrei Beevil will start with the questions.
Good afternoon, Mr. Mardari. As mentioned in the hearing notice, the government agent has offered information to the Commission, which says that you as a judge participated in issuing court decisions in 16 cases on which the ECHR has issued decisions stating some violations of the Convention for Human Rights. After analyzing the material from the government agent, but also based on the previous practice of the Commission, we have eliminated the doubts on you in 10 cases. In the notice for the hearing, we have mentioned 6 cases that shall be discussed. However, based on the explanations that you sent on the 16th of September, the Commission considers that the doubts on other 2 cases have been mitigating, Vizdiga and Harklov versus Moldova. Now we will only discuss about 4 cases on which the Commission still has some doubts on the observation of the ethical criteria. So it is mentioned that it is related to arbitrary decisions. The cases that we will mention are Cucu and others, Produce and others, TA and others, and Falunda Fact. All against the Republic of Moldova. Obviously, you were part in these cases as judge of the Supreme Court of Justice. You were part of the panels that issued the final or the last decisions at the national level in these files. And I will start with some general questions that are applicable to all the cases to have an overview. How do you think, do the judges in the Republic of Moldova have the obligation to apply the ECHR and the case law of the court when there is a conflict between the case law of the European Court of Human Rights and the national legislation? Yes, the answer is yes. If there is a gap in the national legislation, since 1997, the national courts need to be in line with the case law of the European Court of Human Rights, and we need to apply the European Convention directly. When the Supreme Court of Justice issues a motivated decision or an explanatory decision on a certain type of case, as this court has been doing for many years, do these recommendations or explanatory decisions have to be applied by the judges when examining litigations? The answer to this question, in relation to my activity in the Supreme Court, I started in 2014. Up to then, I worked in the first court for 20 years. So starting 2014 and up to my resignation, I think that weren't so many decisions of the Supreme Court of Justice that I was involved in. You know the situation of the Supreme Court of Justice because we could not have a quorum. So in order to interpret some provisions, this has to be approved by the Assembly. Whether these decisions are mandatory or not, I will not tell you the year and date when this was answered, but the Constitutional Court mentioned at a certain time that the decisions of the plenum of the SCG are restricting the right of the judge to have a decision on this case and to interpret the national legislation. So these decisions of the plenum are a benchmark for the national courts, but they are not mandatory. I've been working for a long time, and at some point there were discussions at the national level that in the decisions of the courts there were referrals to some paragraphs of the decisions of the plenum. Later it was mentioned that it should not be done, that it's also related to the decision of the Constitutional Court. I know that this will lead to a different question, that the judges are interpreting the provisions. Do I understand correctly that this is the position, so the position of the Constitutional Court is also your position? Do I understand correctly that these explanatory decisions are like a guideline, but they are not mandatory, they are like recommendations? Yes. You know that the Civil Procedure Code was amended, and we have other mentions. These are related to Article 17, consultative opinions, and so on. Could you tell us what is the role of a judge of the SCJ in ensuring the implementation of the European Convention and of the precedents of the European Court? The SCJ should be in the front line in terms of implementing and respecting the European Convention. When I was working, now I think we have less communication between the national courts, the government agent, and the judges on the application or implementation of the European Convention. So I would like to say that we need more communication and more implementation in practice. So let's discuss each of the cases mentioned previously by me. Let's start with Cucu and others versus Moldova. It mentioned the three claims to the court by Cucu, Tănase, and Badarciuc. These were somehow joined in one case. These applications were concurrent. They are not all from one file. You were a judge in Vladarcic against Moldova. The claimant was accused of some extortion, and there were different violations of the law on the right to safety due to the punishment applied to him. After the trial, Vladarcic filed a case against the state based on law 1545 of 1998 and requested damages for the illegal actions of the law enforcement bodies. Violations of Articles 5 and 6 of the Convention. The violations were found, and 1,000 lei for the violation of the fifth article were granted, 1,500 for the sixth article, and 5,000 other lei. Then there was a decision of the Court of Justice. The appeal was on the value of the damage was rejected. At the moment when the appeal was examined, there was also already enough case law of ECHR on the conditions for an internal domestic appeal, so that it is considered efficient. This is one of the criteria is to have the damage less than the one granted by the first national courts. In other cases, the court granted 6,000 euros for 3 days of detention or 11 days of detention. Could you tell us why did the national courts consider that in the case of the plaintiff who was in detention for a longer period, they considered that 300 euros is enough in terms of damage? I will answer in the following way. The case Cucu and others against Moldova refers to Vodarcic, and the SCJ applied the national law. We have law 1545 alongside the provisions of the civil code on material and moral damage. The national situation was that it was at that point the value of the damage was discussed in the appeal, because we had the dilemma: is this something related to the law, or should we examine the circumstances? So the value of the damage is something that should be related to the law, or these are circumstances that should be approached by the party during the appeal, and if the party does not invoke this, the Supreme Court of Justice would declare the appeal inadmissible because they did not follow the requirements of the law. This is why the SCJ could not analyze if the damage of the lower court were enough. The case law of ECHR, although important, was not always immediately reflected in the national legislation, and this problem of the low amount of damage is still valid today. I think I'm not saying something new for the members of the Commission, especially that some of you are attorneys at law. Regarding the value of the damage, I think this examination cannot be easy. It should be done at the same time in a high number of cases, and this may have important consequences on the budget. So such action should have been taken not at the level of the panel, but at the level of the Supreme Court of Justice. I examined the appeal in 2014, and after 2 months, so this was 2 months after I was appointed as a judge at the SCJ, and I followed the practice that was applicable at that moment. This is why I do not think I should be criticized for respecting the practices of the SCJ. This was what was being done in the Supreme Court of Justice back then. But mentioning to that case in the decision of the Court of Appeal, since I was preparing for answering to the doubts of the Commission. So the Court of Appeal stated that the termination of the trial regarding that person was not based on the fact that the facts did not happen or the crime did not take place. It was terminated because there were other circumstances that eliminate the fact that the person is held liable. I think Article 391 of the Criminal Procedure Code, and we talk over this motivation that the termination of the trial is fair compensation for the person. And based on this and on the current practices, we decided, well, actually the SCJ upheld what both courts decided, the first court and the other court. So the European Court is not criticizing the SCJ. It is mentioning that in the national legislation there is an issue regarding to the low amount of damage. And in this case, even in the Ghana case, the court stated in the 22nd paragraph that if the national law does not allow remedies or only partial remedy, and I would like to say that law 1545 allows for this, but we don't have a clear guideline at the national level on what should be the size of the damage. And here we have Article 41 of the Convention stating that the court should give the damage that it considers adequate. This does not mean that we did not have omissions. I admit that this is an omission. The practice of the ECHR is a lesson for us, and we need to learn from it. Referring to the current practice, when the decision of the Supreme Court of Justice was issued in 2014, there had been an explanatory decision of the Court of Justice since 2012 on moral and material and moral damage based on the violation of Articles 3, 5, and 8 of the Convention. Did you take into consideration this practice? Did the SCJ take into account its own decision when examining this case? I'm asking because in paragraph 20, it is mentioned that one of the criteria is that the amount should be comparable to those offered by the court in similar cases. Also, in Article 22, paragraph 22, there are references to certain amounts, a range that should be offered. This paragraph 22 says that for the violation of Article 5, the damage should be between 600 and 30,000 euros. So this decision was issued or had been issued by the SCJ 2 years previously. I would like to understand whether this decision was taken into consideration. I mentioned previously, and I'll try to explain. The low value of damage, is this something that should be related to the law or should be decided based on the circumstances? I'm not saying that the SCJ should not follow its own decisions, but I mentioned that this issue of low damage was present, is present, and I think it will be present for a long time still at the national level. We are in a difficult situation. On one side, we have the public budget, and you will criticize me because I used to be a judge. I'm not the judge, and I should be impartial. But on the other side, it's complicated to take decisions on the amount of damage. I wouldn't say whether the damage was enough or not. In the explanations, I mentioned that it was probably an omission of the panel in that case. On whether the facts related to damage should have been taken into account on admissibility. So we are discussing about the right to an effective appeal. So this is the right to effective damage. And Article 432, paragraph 4 of the Civil Procedure Code offer the court the possibility to accept the appeal when the actions led to the violation of fundamental rights. So other violations than the ones in Article 3 should be taken into account if they lead to violations of fundamental rights of human rights. This should have been invoked by the party. I explained that the Supreme Court of Justice took into account the decision for terminating the trial, and it was considered that this is a remedy. And I would like to be heard. This issue of the low damage is still present. It's not only from the period when Mardar used to be a judge. It's present at the national level. And I consider that the present or the future SCJ should go to the parliament and to discuss a high number of cases in relation to the value of the damage. And if I may, the Commission mentions the Boychenko case. I agree with the findings of ECHR in Boychenko Christina case. The person was detained for 11 days, but she was detained without having a legal document or a procedural document. I think this is more serious than in this case when the rights were reinstated. This is my opinion. That was more serious because the person was detained without having some procedural documents. And the last question, you mentioned in your written explanations, but also today during the hearing, this issue related to the budget. Could you tell us what is the relevance of the issue related to the budget in examining a case related to compensation of damage for the violation of fundamental rights? I understand these practical grounds, but is this somewhere mentioned in law 1545 or in other parts of the national or international law that the judge should take this into consideration? I said you should not consider that the judge has some moral obligation to do this. I mentioned this given the fact that the changes in practice still needs to be done, and it should be done concurrently for all the cases that are examined in the country on this topic. So this could have important consequences on the budget. I said that the issue on changing the value, I didn't want to say that this is related to each case. The judge does not judge based on whether we have money in the state budget or not. I thought that this issue would arise. But as a judge, I always ask myself, we have law 1545, we have law 87, and you will then ask me questions on this. And these laws are passed by the parliament to collect the damage for persons that incurred some damage due to the fact that the court decisions were not enforced in time or there were illegal actions. So we wanted this. Well, we have difficulties now, although this law was passed. And I'm speaking now about the Ministry of Justice. So the Ministry of Justice has a whole department that defends the interests of the state, and they are the defendants. So they are in the same office as the governmental agent. And I always asked myself whether there is any communication between these two entities that come in front of the court and are defending the state budget. The representative, you will tell me that this is a contradictory process, but never has the representative of the Ministry of Justice, and that should pay the money from the state budget, to say this was violated. In the case of Cuckoo, we had a violation and the money needs to be paid. They never said this. In all cases, in the end, the Ministry of Justice has appeals. They never admit that the person suffered damage. I'm referring to Law 1545. And in terms of Law 87, the whole society knows that the court decisions are not enforced. And in the end, it looks like we are discussing about the fact that the judges offer low amounts of damage.
That's why I see this as an issue in both areas. And I believe maybe in the next future, this would need to be solved. Kind of results from how that Mardari was a judge in SCJ, coming in front of the commission. And I admit this was my mission, that I did not have a dissenting opinion, for example. But there was a practice in SCJ. I did not have a dissenting opinion in that cases, because in my opinion there was a talk about the lack of or insufficient compensation or remedy. I would not to make myself as a victim, but coming from the fact that I was a judge, I've tried hundreds, thousands of cases, and I'm involved in these 6 cases that you've mentioned. Yes, I recognize that all the judges, including myself, should take into account the laws or the lessons offered by ECHR. Okay, Mr. Mardari. First of all, we are discussing all about 4 cases. We mitigated 2 of them with explanations you provided on the 16th of September. One last question to this. What would stop the judges, or what did stop you as member of the panels to provide or to state for the fair compensation in relation or compared or according to the standards from the ECHR? I believe that it's normal to have this trial. We have different opinions, but in the end, it's the decision of the court to decide on the damage that is paid to the applicant. Are there some legal provisions or maybe an objective reason for limiting a judge to provide compensation that is comparable to the standards of ECHR? No, there was no limitation or no standard, let's say so. You mentioned about some written standard or what? No, maybe there are some regulations, legal provisions. No, there are no regulations in that sense. The practice of SCJ was more perseverant in this sense. If it was not the case, maybe today the compensations would be more fair, and the ECHR would not keep condemning. Let's go back to Moldova case. We have 4 applications related in between them. We have Kotovic, Nica, Produce, and Darie. In this case, you've participated in the examination of the second appeal in cases Kotovic, Nica, and Produce. For Produce and Nica cases, you had a single proceeding based on the law H7, and the amounts are not substantially lower than the ones stated by the court. Therefore, this will not be discussed by the Commission. We consider there are no doubts. But we still have the case Kotovic in this connected or merged case. In the explanations you presented before the hearing, you said that the damage provided at national level did not lead to the violation that the court found. But still, in 24th paragraph of the decision of the court, it is mentioned expressly that the claimants kept the equality as a victim following they were provided an insufficient amount of compensation. And in paragraph 34 of the decision, it's involved, it's referred to the violation of the right to an effective remedy. In that case, the applicant Kotovic submitted 5 actions or 5 applications. You participated in 4 of them. The rulings from 20 March 2022, 14 September 2022, and 2 others. And the compensations provided to the claimant for the moral damage were 3,000, 2,000, 1,000 and 7,000. ECHR stated that there was a violation of Article 6 and 13 and Article 1, Protocol 1 of the Convention due to the continuous non-enforcement of the decision and due to the inefficiency of the domestic remedy, which led to the compensation amounting to 2,300 euros moral damage and 404,000 material damage. And these are substantially lower than the ones provided by the court in similar previous cases. 1,300 for Botezatu, another one from other cases, so previous cases. First question is that when you've examined these cases in 2015, 2016, 2020, and 2022, did you know actually about the decision, pilot decision, Olaru and the others, and Banaru and the others? When the court found that in the law H7, or based on the law H7, the national court should apply the same criteria that the convention applies for the payment of damages. And I'd also like to know if, when you've examined those appeals, those second appeals, you were aware of the fact that the second appeal or that litigation was came back from the ECHR and declared inadmissible, with the indication that the applicants would use the domestic remedy according to the law H7. I would keep my stance, the same reasoning, the same motivation, like in the case Cucu and the others. I've tried to apply the provisions of the law H7 from 2011 on the repayment of damages for the non-enforcement or delayed enforcement of the court decision. I did know about the case Olaru. I did, but in your question, you mentioned that it was his fifth time for him going to court in terms of the non-enforcement of the court decision. What were the actions of the judges, actually, of SCJ when ruling on this case? Every time they would rule for the payment of material or damage, because the applicants would go to national courts because the court decision was not enforced. But who was to enforce this decision? It was the state who had this positive obligation to put in force the court decisions to avoid other litigations in court. These court decisions were not enforced and are not enforced still as of today, and every time within the state of limitation or the limitation period, the applicants from Moldova, they used to come to the court, like humbling themselves every time and saying that during 3 years period, I've been renting an apartment. No decision is enforcement. So please pay me this non-material damage, and please let's offset. Let's have a compensation for the damage that I've been through. I understand that these are pilot decisions of ECHR, but if it's for the fifth time, it's clear that the judge would look at the previous aspect, like previous damage for the sufferings. Like the first case would look at the previous damages, or are these continuous? That's why, honorable members of the Commission, it's harder to say, did I know or did I not know about the cases. Maybe you'd blame me for violating the law. I would say I abided by the law. Maybe there were some omissions, but these were not on purpose or serious negligence. That's the situation. It's not in vain that I said I would be the only one coming in front of the Commission to respond for the whole judicial system about the losses in the ECHR. That's my decision. And it's more important that for the evaluation, I have no social guarantee I've received. That's my risk. So I said that's my mission, or mission of my colleagues. I took part with them in the examination of these cases, and the decisions were unanimous. It was not only myself who decided, who ruled on those cases, but yes, I recognize, I assume this decision. We do not blame anyone, and we admire your courage. We would like to clarify something else. Alongside with the case law related to cases Olaru, did you consider in these 4 second appeals the recommendation of the 6th recommendation drafted with the governmental agent, which explained the way to examine the actions under the law HS7 and the amounts recommended? According to this recommendation, the amount of the non-material damage raises to around €600 for 12 months delay and €300 for every 6 months delay. So this recommendation basically stated precisely for a judge the possibility to calculate exactly the amounts of the damages. But nonetheless, this was not taken into account. We are basically in a situation that it's hard to explain. The Supreme Court of Justice is ignoring their own recommendations. I've tried, Mr. Vice President, to explain that the parts would look every time at the insufficiency of this. We would look also at the substance of the cases and the second appeals What you say, obviously this was a benchmark for the judges, for all, not in the SCJ, but all the judges. But at the same time, this was a recommendation for the government, for the governmental agent, for the representative of the Ministry of Justice taking part in these cases. They also knew about this recommendation, and every time they would say that the amount was too high, that was provided by the courts, and the court decisions were not enforced in the end. In the case Produce and others, which you did not ask about, ECHR has stated that in the end it would be the obligation of the state to enforce the decisions. It's not in vain that you asked about Kotovic. It was his 5th time. If you look at the website of SCJ, he went to court 3 times more, because the respective persons, those persons are the same going to court. They have injuries, they suffer several times, but there are people like this that would not go to court. Let's ask you some abstract question. Do you think that if the courts would finally pay this appropriate compensations, damages, would the litigations end? I think no. I don't think so, because in one of the cases we had, if I'm not mistaken, is Ganya, sorry, ECHR said or stated that till the end it's the state's obligation to enforce the decision, court decision. And in one judgment they said that the claimants would invoke different reasons. Ownership's final decision that was not enforced, by which they were provided, or they had to be provided by the state space to live. That's why the state had to give them a space for in their ownership, a space to live for property. The court stated that the state is not obliged to give you a property. The state is obliged to give you a space, living space for rent. That's after that the problem disappeared. But the obligation, positive obligation of the state is to enforce the decisions. I think you know, for example, that if court decisions are not enforced, the municipal council tried in that regard to offset or to provide compensations instead of this living space. And from I've read in media, this is a criminal. There was a criminal case related to a civil servant that violated the law. So, in my opinion, as long as we compensate the damages of that person, the non-material sufferings or damages of that person would still continue till the state would not fulfill their obligations. Thank you very much. Okay, let's go now to 2 cases that are a little bit different. TEA and the others against Moldova. It's focused on the removal of a child from the care from the grandparents, and the child was decided to be taken care of by the biological father, but he had seen his biological father only 5 times in a 5-year period. And the decision was that the domestic courts did not look at the best interest of the child. You are a member of SCJ that rejected the second appeal of the grandparents and rejected the Court of Appeal decision who decided the transfer of the child. It was said that SCJ judged only procedural aspects. But nevertheless, ECHR in paragraph 61 of the decision says that the Court of Appeal and SCJ, even though they looked at the opinions of the authorities, they did not give any opinion or reason for why these were not accepted. So our question is Article 42, paragraph 4 of the criminal procedure, civil procedure code at that moment. Did it give the SCJ the possibility to analyze if the Court of Appeal did look enough at the best interest of the child at that moment? if I have the permission, SCJ admitted as a priority the best interest of the father, not in favor of the grandparents. So, if you ask, did they consider this or not, the actual circumstances were invoked in additional appeal that the Supreme Court of Justice, in its ruling of admissibility, found that these were submitted with delay. That is why that specific case or litigation looked at the opportunity or the best person to live with for the child. And ECHR's decision, let's say, I might say it's not an absolute truth. This litigation was examined according to the domestic legislation, according to the provisions of the Family Code, and the court at that moment did not find the exception provided for in the Civil Code, which said that in exceptional cases the child could be transferred for being taken care of to grandparents or other relatives or other people. And that is why at that moment, moreover, I don't know if I will convince the Commission, but my subjective vision would be that the materials of that case included the court decisions of all courts, first instance and the Court of Appeal. And by that, the biological father was involved in another litigation in which he was in conflict with the grandparents, and he wanted to be decided as a biological father. So it was a case on deciding on the paternity. This was another of the reasons for which the biological father wanted to take care of the child. The ECHR, according to what I understood, did not deny that the child might have been transferred or sent for being taken care of to the father, but they said that, or they mostly said that this was too early. I think they said the child could be taken in custody both by grandparents and father. Moreover, without examining the additional appeal invoked, in which was said that all the authorities stated that the best interest for the child would to remain with the grandparents, we did not look at this, at the circumstances, and we understood or stated that the child was to remain with the father, in the custody of the father. When we talk about children, having the child move from one person to another, it's difficult. I had a service trip in about 2000 when a first instance in Finland told me a person was convicted the court was convicted for the fact that the court did not send in due time the child for care to the father or the mother. So the rhetorical question at that moment, because we were discussing a lot whether the convention had to be applied or not by the domestic courts, for me it was important to understand the consequences of the judge that did not look at the term, at the deadline in that invoked case. The child said, I examined the case of a child for 9 years, and the Finnish state had expenses incurred for that. So I do not feel frustrated for the fact that the child was where he had to be before the litigation was started. maybe it's not related to our case, but at that moment the panel decided to, by not looking at the additional appeal, that the interest of the child would be to remain with the father. I told you it's hard for me to talk about children. Okay, let's move to the next case, Falun versus Moldova. In that case, the court found the violation of Articles 9 and 11 of the Convention. Following the declaration of organization as being as an extremist one, the solution of this one and non-provision of damages as a result of violation. You took part in the second case on the dissolution of the association. In your explanation, you said that this proceeding was conducted according to the domestic law, but you admitted that in the decision there was a mistake, which should which is due to the lack of examination of the context. Could you tell us if the proceeding was respected, provided in Article 6 on the law, from the law on the dissolution, or law 54 on the dissolution of the association, the claimant association? As a response to your question, I would say that this is something new for Moldova. It was new in 2015, in 2016 too. The ECHR decision, as I said, referred to two proceedings. First was to the declaration of the symbol as being an extremist one, and the second related to the dissolution of the association. As you mentioned, I was part in the second case, in the last one. The decision to dissolve the Falun association, it was taken based on the legislation in force at that moment, Law 54 of 2003, on the combating extremist activity. At that moment, there was no judicial practice on applying this rule. Well, that law in that year, in 2015, had not been applied before in Moldova, to my knowledge. In 2015, I took part in the examination of the second appeal after the symbol of the association was declared as an extremist one. So there was already a court decision that was a base for the dissolution. The Commission referred to two cases, one against Switzerland and second against Poland, but those cases were a little bit different. There was no discussion about the extremist symbol in those cases. I participated in examination of the second appeal after these two cases were examined in 2015 at a distance of a month. But if you ask about Article 6 in that law, you shall know that all the time things are seen better afterwards. Yes, that's true, actually. Because when I did not read actually, but I tried to answer to this third round of question coming from the Commission, believe me, it was very hard for me. That's why I referred to the fact that everything is becoming known later on. So after an analysis, I understood that possibly the subject was not to be addressed in court, but this is post factum. Actually, was something new for Moldova, no precedent before. So to have a more clear answer, you admit that the procedure for dissoluting this association was not respected. I wrote this in the answer to the areas of doubts too. But I tell you that this fact was later on understood. And in both cases, I don't know why the best moment was I was the head of the panel, and the second I was a rapporteur. Honestly, I was the happiest that the rights of those persons were reinstated. But this was done by the application of reinstatement that were sent. But this is not an added value for me. At that moment, I just respected my duties, and this was to be. Unfortunately, the decisions of SCJ, you know that there were some not enforced for 21 or 22 months after the review. Thank you very much. I don't have any questions. Do your colleagues have other questions?
Thank you. I have two very simple and I would say summary questions. The first one, when considering the compensation, how much do you base it on the state budget situation and how much on the decision practice of a European Court of Human Rights? I talk about proportions. Could you please describe us?
I don't have a scale to measure the proportion, but every time the decisions of courts and SCJ were based on the law, and every time provisions of ECHR were to be taken into account by which previously damages were paid. I could not measure right now. I could not have a scale to measure it now to say that judges would be guided more by the interests of the state. It's the interest of the aggravated or the defendant. Sorry, that's the answer. I don't have an answer. All the time, the judges follow and are to follow the interests of the applicant, the one who suffered following the non-enforcement of the court decision or damages coming from the law enforcement or prosecutor offices. But we also have some loopholes or gaps in legal aspects in terms of damages.
And my second question, what would happen with you if you didn't take the argument of a state budget as your task, but based on a decision on the European Court of Human Rights?
It's a challenging question, actually. Nothing happened to me during that period as I worked as a judge, and not only in judicial system. I did not work anywhere for 32 years, sorry. And as you can see, there was no disciplinary sanction applied to me by the state, no liability applied to me. I really hope you've seen this from public information. I don't think that the state or the judge might have suffered as a result of non-provision of this insufficient compensation. The judge has to judge or to try. The state is not involved in here. We have to apply the domestic legislation and provisions of European Convention of Human Rights. I don't think that someone would be sanctioned for ruling for increased compensation to be paid or not. But you are a member of the Commission. You are in Moldova for already some time, and I think you're reading or getting informed of what is happening in the judiciary system. For example, a recent case when a person was provided a compensation or damage amounting of a significant amount, let's not name the amount, and what actually happened with the media. The media, they criticized harshly the court decision for being so high. That's why the judges are not sanctioned directly, but there's a pressure from the society in terms of stating for these damages, these amounts. I'd like you to take it into account.
Thank you. No more questions.
Any other questions? Mr. Oster?
I have a question on the TA and others against Moldova case. As we know very well, practically in the cases that involve minors and their interests, regardless of the nature of the litigation, an important role is played by the guardianship authorities, be it the departments for social assistance that are involved in the litigation. And in this case, the guardianship authority, maybe in its opinion or report, referred to the relationship between the child and the grandparents. Again, based on the practical experience, these opinions describe the living conditions and the atmosphere in the house where the child is living. And probably in the TA and others case, this opinion also described the moral, physical, economical situation of the child. And ECHR found that Article 8 was violated and referred to the fact that the National Court did not take into consideration the opinion and the findings of the guardianship authority. I would like to find out what is your opinion on these circumstances. As a judge from the first court, where I examined dozens, maybe hundreds, maybe tens of thousands of cases, I would like to tell you that the opinions or the reports from these authorities are important. I'm not denying this. However, they are not the decisive factor. In the end, the power to determine the domicile for the child, whether it is for the parents or the grandparents, is to the court. These circumstances were described in an additional appeal where the court found that they were submitted late. And this is why the ECHR criticized us. I agree with the criticism that was mentioned in that decision, but however, I'm starting from the opinion that this relationship between the parent and the child is continuous. Today, the relationship can have one form, they can change in time. This is why the national law allows the parties to go to court on the same topic of litigation, because there can be changes anytime. I'm not sure if I fully answered your question, but this was not analyzed at that point because it was submitted late. And we considered that the best interest of the child is that of being with the father. Mr. Mardari, I will refer to the Falun Dafa case. This was a high-profile case in the media. It was considered that it was influenced by the political sector. There was something related to the Embassy of China. There were pressures to forbid this Falun Dafa organization. Did you feel any pressure or intimidation from politicians to take a certain decision in this case. No. This was the decision and our interpretation. As mentioned, we misinterpreted the provisions of the law. This was something new for the Republic of Moldova. And the case law of ECHR was not very clear in the application of the provisions related to this case. Thank you.
All right. It appears that that concludes the questions by the commission members. Judge Mardari, before we end the hearing, would you like to say anything? Would you like to make a brief statement?
My statement is the following. First of all, I would like to thank all the members of the Commission, of the Secretariat, for putting a lot of work into this. Actually, I left the system when the law on the assessment of the judges of the Supreme Court of Justice had not been passed. So there was this, we didn't have the new law on the SCJ. I would like to state that I will be asked, maybe not by you, why I left and why I want to come back. I want to come back because I have a lot of knowledge and experience, and I want to do things better than I did before I left the system. My colleagues criticized me for leaving. Secondly, I was not asked, but I received this recommendation to come back to the judiciary if I pass this test. I'm putting a lot into this. The stake is what I accumulated as an experience in 32 years in the judiciary. I did not work in any other field. This is where I developed myself, my personality. I was guided by famous people. I started working in '91 when we didn't apply the ECHR legislation, but the Soviet legislation. It wasn't easy back then. It's not easy now, I think. I worked in different periods under different governments. And this has allowed me, because I consider myself a responsible person, maybe I'm not 100% fair or correct. But this was it. I would like to thank you once again. When the commission or the secretariat said that 7,926 pages were processed in my case, I calculated that this means 30 volumes. This is a huge amount of work. And I can tell you honestly that I cannot believe this. Now I'm retired and I have followed the activity of the Commission, and I cannot believe that such a huge amount of work could be done by you for one person. I wish you success, and of course the decision is all up to you.
That then brings us, Judge, did you have something else you wanted to say? Oh, okay. Well, then that brings us to the end of today's hearing. Thank you for your submissions and your answers to the Commission's questions. After the hearing, the Commission will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 65. The Commission will strive to complete its report and announce its conclusion as soon as possible. It generally seeks to do so within a month after a subject's public hearing. The hearing is now closed. Thank you and good day.